you'll have to take that. So
Okay.
anyway, you guys, good morning, everyone. Thank you so much for your patience. Welcome to our online presentation on trusts and POAs. My name is Yolanda Hensley, and I'm your client services representative here at PRC. I work directly with sales and also with our client services department to ensure that our clients are well taken care of. Your presenter, you've heard her already, and a lot of you know her. She's Angel Booth. She's our senior sales executive. Angel is responsible for all account management and onboarding of new clients. She's worked in the industry for 18 years and counting, and will be walking you through the basics of working with a trust and power of attorney. Your lines will be muted for the duration of the presentation, so if you have any questions during the presentation, please type those into your questions panel on your screen, and we will get to those at the end of the presentation. And any additional questions that you may have after we conclude the presentation, you can direct those to client services at prclosings.com, and we'll go ahead and put that on the screen at the end of the presentation as well. So thank you very much for choosing PRC for your educational needs. Again, thank you for your patience on this as we got started. And now, without further delay, let's go ahead and get started. Angel?
Perfect. Thank you so much, Yolanda. And again, thank you guys all for dealing with us through our technical difficulties this morning, but we're happy to be here with you. We're happy. I wish I was able to actually see you, but I think that would have probably caused a little bit more of a technical difficulty, so I'm glad I didn't go that route. In any case, today we're going to talk about trust and power of attorneys. I mentioned it briefly earlier. This is just a quick overview to show you all kind of what we're looking at from a title perspective whenever we get a file and we're dealing with being presented with a trust and or a power of attorney. It's very common for them to be used consecutively. We'll have both, and sometimes we'll have either or. So this, again, is just a quick overview to just kind of help you and show you some of the things to kind of watch out for and just to kind of know what to expect and why these things matter. And always, if ever there's a doubt, if ever there's a question, just give us a call and we will absolutely do our best to make sure we help you through it. So I'm going to go ahead and get started, and we will go from here. All right, I might have to move some things around. I have my panel up just because I want to try my best to kind of see these questions, but they might get in the way of the wording, so don't mind me if you see my mouse moving all over the place. All right. There we go. All right, so we're going to talk about trusts first. And that kind of brings up the question, well, obviously, what is a trust? Many people don't know that it's an estate planning tool, which is kind of sometimes what puts us in a tough position because this is considered estate planning. There are very specific things we have to be mindful of whenever we are directing a client, because this is a supplement to a will, and we have to be really, really careful. We don't ever want to mislead or misguide someone and get in the loan. So any changes, amendments, modifications, although us as the title company, you guys as the lender, and even brokers, you know what needs to happen. We just have to make sure that the request is coming from the borrower so that it's understood and the borrower understands what's happening and what they're doing with their quote-unquote estate planning tool. It helps them manage their property during the duration of their life, and we always encourage that they seek legal counsel when they are initially creating that trust. And the purpose of the trust is to allow the property owner, which we consider that to be the trustor or the grantor or the settlor, to transfer their legal ownership to a person or institution, which is the trustee, to manage that property for the benefit of another person, which would be the beneficiary. And the trust has three parties. We're always going to be looking for who is the settlor or the trustor, and that's the person who created the trust. And then we're looking for the trustee, which is the person who is authorized to act on behalf of the trust. That's the person who is typically going to be signing on behalf of the trust. And then we're also looking at who is the beneficiary, and that will typically be the settlor or trustor, which could be the immediate beneficiary or the contingent beneficiary. And that is basically the contingent beneficiary doesn't come into place until the immediate beneficiary has passed or maybe becomes incompetent. So how trust affects reverse mortgage transactions, and they're obviously going to vary depending on the state, the lender, and HUD guidelines, and also title guidelines. So we as the title company, when we go to review a trust, we're looking at it from a title perspective. The lender is also going to be reviewing that trust, and they're going to be looking at it from a lender perspective. So many times, you guys might notice when we send a trust review over, at the bottom it'll say, this trust is approved for title insurance purposes only. And even with that approval, there are going to be circumstances where the lender reviews that trust, and there might be some things underlying in that trust that they're not going to be okay with, which is going to cause for the borrower to need to make some amendments to that trust. And again, that's just because the trust and its capacity varies depending on who is reviewing that trust. The trustee and the borrower must sign the loan documents. And what that means is that the trust is its own capacity, even though it's for the benefit of the borrower. Whenever you're dealing with a trust, the people signing on behalf of that trust, they have to sign as trustee, but then they also have to sign as individual. And that's kind of where we plugged in the power of attorney piece into this, so that people understand that it's two separate entities. One is on behalf of the trust, and the other is on behalf of the individual, behalf of the borrower, whoever's getting the loan. Here's some of the title and settlement requirements that we're going to need just to simply review the trust. We're going to need all executed amendments and the full executed copy of the trust before we can review it. Sometimes we can accept a trust certification. It just really depends on what is listed in that trust certification. Sometimes it's very limited as far as the information that's reflected. So obviously, if we don't know certain details of the trust, we can't make a trust approval. I would say we could possibly do a pre-flight, which means we will look at it, but once we review it, if it doesn't meet all the criteria, we are likely going to ask for the full trust and any amendments as well. We're going to want to confirm that the trust is for the benefit of the borrower. We want to make sure that we know if there are any deceased parties involved, because that matters. It's very important. The trust could change dependent on if someone passes away. And then we're always going to want to make sure that we know up front whether or not the borrower is competent or not. If we don't know these things, it's not to say that it would cause a problem later. It's just that the sooner we know of any issues, the sooner we can relay that and make sure we are giving you guys all the information you need to make sure that this loan is going to work for you all and the borrower, obviously. And just a quick note, again, as I mentioned earlier, when title reviews this, we're going to be reviewing it for our capacity, but the lender will also be reviewing it for lender and HUD guidelines as well. And then here's a quick little checklist. I'm going to have to move my little screen out of the way. There we go. Here's a quick checklist of the things that we're looking for when we do get the trust. We're looking to make sure that all the borrowers are immediate beneficiaries, and vice versa, all the immediate beneficiaries are the borrower as well. And that's a lender requirement. Again, the trust is for the capacity of a specific individual, so we have to make sure that the immediate beneficiaries are very clear as to who has rights to that property. We want to make sure that we receive the correct trust. Many times trusts are created with very similar names, and there might just be a one-off a date difference or, a middle initial difference or something of that nature that, makes it a totally different trust. So we have to be very careful that we do get the correct trust. We want to verify who the trustees are and confirm that the trustee has the power to borrow. And we want to make sure that the trust is notarized. A copy is sufficient, but we do want to make sure that it's a complete trust. Everything, all the I's are dotted and T's are crossed. We want to make sure that the trust is revocable, and that is for all HECM loans, and that, again, is a lender requirement. And then sometimes we might have an irrevocable trust that may be acceptable to some lenders, but it depends on the full scope of the trust being reviewed to allow them to make that determination. We're not, privy to that. It's every specific lender is going to be different on how they view that. There we go. All right, so here are some reasons for trust denial, and these are pretty common. It's not, don't ever think that you submit a file and it doesn't work out the way you intended, because these things are very common. I would say at least 85% or more of the business we deal with our type of loans with reverse mortgages are likely going to have a trust. That's just pretty standard. So sometimes we have a situation where the trust is irrevocable, and some lenders don't like that, depending on whatever that verbiage is. Sometimes we don't receive a complete trust. The borrower has had this trust for God knows how many years, and they're older, they maybe didn't put it all together, or maybe they only had pieces of it at one point in time. But needless to say, we'll get a trust and there's pages 1 through 10, and then you've got 46 through 59, and then you've got 100. That's not okay. We have to have the full trust. And I know it's difficult sometimes, but those could be reasons for denial. Sometimes the trust certification, as I mentioned earlier, could contain insufficient information. Depending on maybe someone passing away, a trust could split into an A-B trust, which could cause some issues there. And then just the deceased party itself could just pose an issue with the trust needed to be distributed, which is a whole nother issue as well. But these are just some of the things that come up when we're dealing with trust denials. And just as a quick note, any borrowers in Texas, they're not permitted to close with the vesting held in a trust. That's a very specific to Texas rule, and we do our best to make sure when we're dealing with those kind of states with different guidelines that we are always letting you guys know these things up front at the onset of the open order. As long as we know that the property is in a trust, or if you guys open order with the trust, we'll let you guys know what you need. A couple more reasons could be that there is no power to borrow, or maybe the trust is not executed. The one where it's not executed, we've had situations where we could still review it to make sure, everything is okay, and then it might be a requirement that the trust has to be signed at closing, or, if it's really involved, they may require the trust to be signed up front before we could submit a final approval. But there are always ways to work around, most times, not all, but most times there's a way to work around when there is a trust denial to make sure it gets to where it needs to be approved properly. Sometimes we have an issue where immediate beneficiaries are not the borrower and vice versa, or even maybe the trust just needs to be distributed. So those are some of the more common reasons for trust denial. And here I'm going to give you an example of what the signature line should look like whenever we're dealing with a trust. To us, as a title and settlement company, these things are second nature to us, and so we try to do our best when we're dealing with notaries at the signing, as far as, the docs may be drawn and it's not written out or spelled out specifically, but these are just common things that it has to be this way whenever you're dealing with a trust. So the signature lines for the trustee portion of the loan document should always look like the below. You'll have basically, the borrower's name, comma, trustee. And that trustee, even though it's written on the signature line, it does in fact need to be signed, signed out right along with the borrower's name, or the trustee's name, I should say. Many times we have situations where the file goes to closing, the docs get signed, and everything got signed, but it wasn't signed properly, which causes funding delays, and the notary having to go back out. And we try our best to make sure we're hiring the best notaries that we can, that are reverse specific and are very familiar with dealing with trust and how the signature line should read, whether or not it's specified or specific that they need to actually write that word trustee in there. And just as a note, the lender will require the individual signatures of the HECM borrower to sign on the security instrument. So some documents will have both trustee and individual. Some will only have trustee, and some will even only have individual. It just depends on each specific document once we get to the point of doc draw. And then this is an example of how the vesting should appear. It should always include the trustee, the name of the trust, and the date of the trust. That's standard. Now, just because it's standard does not mean that all trusts are recorded that way. There are plenty of times when we go to pull vesting and it just says the Smith Trust. That's it. That's not okay. It doesn't tell us who the trustee is, doesn't tell us the date of that trust, and those are things that should be of public record whenever someone is vesting their title into a trust. So the below example of John Smith and Jill Smith, trustees of the Smith Family Trust, dated July 29th, 2011, would be a proper way of how the vesting should appear whenever we pull title. It's not going to be that way every time, though, and that's, again, standard. We know that, but we can always fix it as we go through our transaction to make it right. Some trust vesting issues. Now, these are just kind of things that come up. Again, we know what we're looking for when we pull title, when there's a trust, and then sometimes these are the things that come up. Maybe at the time when the borrower put their property into a trust and named a trustee, maybe they named their daughter as a trustee. And at the time, for instance, my last name, my maiden name was Smith, and now I'm a Booth. So if I, was the trustee on my parents' trust, and then I get married, obviously my name's going to change. And if the trust was never amended to reflect that name change, we would have to update that through our transaction to make sure that the trustee's name matched their name as it should reflect on their ID so that it can be properly notarized. Maybe the trust was amended and restated, but that wasn't reflected in the current vesting. Again, these are things that happen throughout time that I'm pretty sure the borrowers aren't thinking about, but they do need to be corrected because we want to make sure that any documentation that's being provided is properly reflected throughout our transaction, and that's our job to fix it and make sure it's all right. Another example would be the trustee is not stated correctly within the vesting, and there's just an example below, like I had mentioned earlier, just says Jill Smith Trust dated, and it gives the date, but it should say Jill Smith, who is the trustee of the Jill Smith Trust, dated January 2nd, 2017. That would be the proper way to reflect it. And anytime there's issues, I would say 99% of the times we can absolutely fix it with a deed. We don't have many situations where we have to turn a file away just because, you know, we can't fix it and we have to send the borrower to an attorney, but that does happen. It's just not common. And here are some requirements for deeding out of a trust. We're always going to need a copy of the full trust and any amendments. We could potentially need signed supplemental instructions by the borrower at the time the deed is executed. And what that means is just kind of back to what I had mentioned earlier about the trust is an estate planning tool, and anytime there are changes being made, we have to make sure we're doing our part to ensure that it is in fact a borrower who is making that suggestion. No matter if it's us as title saying, okay, we can't approve this trust because of these reasons, this needs to happen, and we relay that to you, the lender just has to make sure, you know, dear borrower, this happened, this isn't going to work this way, this needs to happen, do you understand that, are you okay with that? And that supplemental, signed supplemental instructions is basically what's giving us that understanding that it is the borrower's request to do so. Which is, again, why this bullet says the directions should be provided from the borrower to remove the property out of the trust, because that happens. Sometimes we just can't close a deal in the trust, and that's okay. As long as the borrower understands that if they want this loan, this is what needs to happen, and they're comfortable with that, that's totally fine. It just has to come from the borrower. We've had some situations where the deed prepared has to be done by an attorney, but again, many of the times it's the settlement teams that will prepare those deeds and make sure everything is right, and we will do that through our transaction along the way. And those are just pretty standard, typical requirements. All right. All right, so now we're going to talk about when we're dealing with a deceased beneficiary. Again, as I mentioned, sometimes you're going to have a trust, and if a person passes away, it could split the trust, and that could cause some issues. One or both of the trusts could become irrevocable. Again, that's a lender-specific issue. We will always be able to review it and let you know. So again, the sooner we know about a deceased beneficiary, the better. That way we can tackle it head on and get you guys the requirements that you need so we can get it done to get the file moving forward. If we have a deceased beneficiary who's the last surviving trustor of the trust, we have to look at the section of the trust that describes about what's supposed to happen to the property. And sometimes within that verbiage of the trust, we can see that the trust needs to be distributed. This is not something that happens commonly, but it is something that happens. And when that does happen, we like to make sure we know about it sooner than later. I mean, right now, everything that's going on with COVID and there being delays with, different offices being able to accommodate or in making changes of that nature, it's even more important now more than ever, just because it's not that it can't be done. It's just the time frame that it's going to take for that to be done. So just be very aware of that whenever you're dealing with a tough file. Know right away. Let the escrow team know right away. Sometimes you might not even have the order yet. Give us a call. Ask us these questions. Let us help you get the deal to where it needs to be, so that when you submit it, you're not now waiting 2, 3, 4 weeks out on something when we could have addressed it before you even opened the deal, and your appraisal is expiring and your GFE quote's not good anymore and all of that good stuff. So just make sure you communicate as best you can with us, and we will always be here to answer any questions and help you guys along the way. I mean, that's what we're here for. We want to be a partner in it with you guys. This portion is kind of talk about when you're dealing with a deceased settlor, and that's going to have the situation pop up where the trust could divide into the subtrust, or where the subtrust could be irrevocable. And then we have situations where we've got deceased trustees if they are not the borrower. If they're not the borrower, all we're going to need is the original death certificate, and then we're going to have to prepare an affidavit of change of trustee, or affidavit of death of trustee, and then advise of any vesting changes. All that will do, in essence, will update the trustee's name along with recording that document, and that information will be of public record, and then that's a simple fix. And PRC is always going to be the one to prepare those documents, and we'll always let you guys know if an original death certificate is required. There are a couple counties who will take a certified copy, but in most cases we do ask for the original, so that's another important thing to know when you're dealing with trust, or any deceased party for that matter, knowing upfront whether or not your borrower has those original documents, because if they don't, they will have to be requested. And I think I just had a file about 2 weeks ago where the borrower's sister had to get involved and help order the deed. And even with everything going on, it only took about 2 weeks to come back from vital records, so that wasn't too bad. So if you guys know anything about any deceased party, please be sure to ask the borrower if they have the sufficient documents that we'll need to make sure we can keep the file moving forward. All right, so when we're dealing with an incompetent borrower, we are going to have a situation where the successor trustee will come into place, and that's who's going to be signing if the borrower is deemed incompetent. So that would just be an update change to the current trustee, which is in essence the borrower, and then the successor trustee would come in and sign on behalf of the trust for the borrower. And then if you're dealing with a power of attorney or a conservator, that signature would be for the portion of the borrower as an individual. So they're two separate entities, as I explained earlier too. And just as an FYI, the POA is only used for the capacity of an individual, not in the capacity of a trust. Although I will say that there have been some situations where a trust can specifically lay out and confirm that a trustee has the right to act as POA, but again, the POA would have to be signed by that said trustee, and all of that would have to be specifically written in the trust, and that is not common. It has happened, but that's not a common thing. All right, so I mentioned earlier about trust distribution and how that could be required sometimes depending on someone passing away or some major life-altering change or event within the trust. And it just means that, again, after the death of one of the surviving immediate beneficiaries, the trustee is going to be responsible for making sure they're managing the assets involved within the trust, or any of the individual things related in that trust according to that trust agreement. So it's very important that we look at that closely. If we don't, that could be a potential claim. If we allow a trust to be submitted and approved, we're not doing our part to protect the borrower and also to protect the lender if we pass on that. So we don't ever want to tell you that a trust has to be distributed and we can't close the deal with it in the trust. That's the last thing we want, but just know that if we do ever have to, deny a file because of that reason, it's just to make sure we're protecting the borrower and the rights to that property to make sure everything is done properly. Uh-oh, there we go. Oh, I think I went back too far. Hold on, let me go back. There we go. Can title distribute a trust? I'm so sorry, we cannot. It is a very involved process, and it is something that we will have to seek the direction of an attorney for before we can move forward whenever there is a distribution. We can't do estate planning, so it's really tough because our job is we want to make sure we are helping to make these loans work, and we want to make sure that they're insurable. So we can't give direction, but I'm just going to be completely honest with you. As long as I've worked in the industry, I've got a lot of partnerships and a lot of colleagues in the industry, and I'm going to make sure that I personally and my teams personally are going to do our best to at least point you in the right direction. We can't go and give you a specific attorney's name, but we will always lead you in the right direction and give you information that's going to help you get to the end result that will be needed to get that file closed. So any specific questions on that, you guys are always welcome to email me and ask me any direct questions specifically, and I will do my best to help answer those questions the most politically correct way that I can to make sure that, again, we don't want to be held liable. We don't want you to be held liable as far as any estate planning, but again, our job is to help the borrower, right? So if that's what we need to do, we're going to make sure we're giving you the information and the tools that you need to make sure that that gets done. So these are going to be our requirements for trust distribution. We're going to have to review the trust and the death certificate to confirm that the distribution is required. And then we're going to need a deed prepared by legal counsel and executed by the trustee into the borrower's name, basically taking it out of the trust. If applicable, we may need an affidavit prepared by the legal counsel, which I believe is just indicating that, the borrowers want to come out of the trust and we need a deed, or we have provided a deed going into them as an individual. Many times we don't have to go that route. Just a simple letter from the borrower instructing us to do so allows us to move forward with that. And then we'll need, sometimes we do need the recorded deed up front. Many times when there's a trust distribution, even the lender will not allow for the file to move forward until it is in the borrower's name as an individual and out of the trust. And when that happens, please do let us know if it's our file, so that way we can have an executed copy of that deed before it goes down to recording. And then if the borrower is able to get a recording confirmation number on that deed, that helps us out immensely. That means that we don't have to wait on the county records to update before we can change the vesting. If we've got a copy of the executed deed and we have a county recognized recording number, we can change the vesting instantly. We don't have to wait on the county records, which could take, certain counties can take longer than others. So just be very mindful of that. Any changes to the vesting, changes on to the property, let us know up front, and any recording information you have will always help us out a ton. All right. Oh, and as a quick note, title requirements are subject to change depending on each unique situation. This is why I always stress share as much information as you need to with us, and you don't have to worry about, you don't even have to email us, just call us. Call us, we'll talk you through it. All right, so that covers everything on the trust portion. I'm going to open up my little window, and I'm going to see if there's any questions in the question box. I know we said we're going to hold them to the end, but I just want to see if anyone's put anything in there. And I'm not seeing anything, so I'm just going to take a breath, grab a sip of water. I told you I was long-winded, and then I'm going to head on into power of attorney. All right, okie dokie. Oh, here we go. Here we go. Okay, same thing here. What's the power of attorney? Well, it's a legal document, and it's going to appoint another person to manage the borrower, i.e. principal's financial affairs. And a POA is typically used when we run into a borrower that is mentally incompetent. They are physically incapacitated. They could have I don't even know, muscle dystrophy or something where they can't sign properly. They can have severe arthritis. They could have had a stroke. And, there's multiple reasons of where they're sound mind, but they just can't physically sign. And then we have our borrowers sometimes that they're just really busy and they are more than competent, but they just don't like to sign. So they appoint a POA to kind of handle their financial affairs for them. The type of power of attorney that we're going to need is always going to be a financial power of attorney. We can't use a medical POA at all. It has to make sure it allows this person to act on their finances, on behalf of their finances. Original power of attorney is going to be required at closing, and it must record with the mortgages or deeds of trust if it's not already of record. Many people who obtain or have a power of attorney, they don't record it. Sometimes, for whatever reason, they will file it with the county, but they don't actually record it. It does need to be recorded. And as you know, we do have many borrowers who do not like to give up their original documents, and we understand that. That's okay. If that's the case, we do encourage you to let us know if that's the case, so we can kind of help walk you through having that borrower record that power of attorney on their own. And just like I mentioned before, taking it down to record, getting that recording stamp, that number, provided to us, so then that way we can update the information that we have, and we won't require that original power of attorney anymore. As long as we have the same document that's of record, we should be fine to go ahead and utilize that power of attorney. The different types of POA, minimize that, POAs that we have is we have the standard, the durable, and then the springing. So the standard is going to be effective immediately upon, once it's signed, it goes into effect. It doesn't have that durable verbiage, and lenders may or may not reject it depending on their specific requirements. And also with the standard power of attorney, the borrower would have had to been able to sign the application. So that's pretty specific. So we typically like seeing the durable power of attorney. That one's a lot easier to use because you don't have to worry. It's going to be effective no matter what. Even when the borrower becomes incompetent, it's already in place, nothing changes. So that's going to be the most common one we're used to seeing. And then the springing power of attorney, that one only becomes effective after the borrower has become incompetent. So just like I said, a quick little snippet of the types of power of attorneys we have. Whenever you're kind of seeing these documents, try to be on the lookout on whether or not it's going to be standard or durable. Those are the most common ones we see. The springing ones, they come into play, but not as much as the standard and the durable, and by far the durable is the most common one that we see. All right. And this is just a quick sample. I'm pretty sure you guys are very familiar with what power of attorneys look like, but this is just an example of one. It's basically going to list its specific verbiage to the document that it is. It'll have the principal's name, which would be the borrower's name and address, basically, the agent's name, which is the power of attorney, and their address, and then these powers below. Normally, normally between A and N, all of them are typically the powers that are going to be listed in the power of attorney. I'm so sorry. But if they're not, again, we will let you know, and we will give you guys a heads up if we have any issues that might not give us a clear title to move forward with that power of attorney, and we'll let you know what we need. Sometimes it could be doctor's letters that are going to be required to allow the power of attorney to be used. It just kind of depends on each individual scenario. All right. So this is what is going to happen when we're dealing with a competent borrower. We're going to either review the durable or the standard POA, and it should be acceptable. We've got to make sure that it meets all guidelines. We've got to make sure that we have the principal's affidavit, and that's got to be signed and notarized by the borrower. And again, what that does is it allows the title to review it to make sure that there's been no changes made, and that the borrower was very aware that they have a power of attorney and they're okay with this person signing on their behalf. Because they're competent, they can sign that principal's affidavit, and then their power of attorney can sign everything else. The borrower would have to be counseled, and they should be signing the loan application as well. And then the power of attorney must sign the affidavit of attorney in fact, just to kind of make sure that, yes, this power of attorney is valid, and I am signing on behalf of this borrower, and there have been no changes since this power of attorney went into place. And just as a note, PRC would be the ones providing all of the affidavits necessary on all the POA transactions. Now it doesn't want to go. All right. So when we're dealing with an incompetent borrower, we're going to have either a durable or a springing power of attorney. And either one could be acceptable. Just have to review it and see where the chips fly. We're going to need the power of attorney possibly to have 1 to 2 doctor's letters, dependent. It depends on the wording and the verbiage in the power of attorney. Sometimes it's not clear by the verbiage in the power of attorney, the capacity of the borrower, or when the borrower became incapacitated, and that's why we might require a second opinion doctor's letter, just to make sure we're moving forward in the right direction and that we have everything that we need to use that power of attorney. And then in some cases, the attorney, in fact, is going to have to sign a court order to determine that the borrower is incompetent. These are things that they happen, but that specific requirement, that's not a common requirement. And then we've got the power of attorney must sign the affidavit of attorney in fact, and again, PRC will provide that document. As a note, PRC specifically, we only require one doctor's letter. It's just, like I mentioned before, sometimes it's not very clear, or maybe the doctor's letter that was provided is too vague for a clear passing on a POA, which is why they would require a second opinion and have another doctor's letter. These affidavits are just an example. I don't know when we changed the title of this document, but this is the true title of this document. It's called an affidavit of lack of knowledge of termination of power, and that is to be signed by the power of attorney. And then on the right is an example of what the affidavit of principal looks like, and it's just basically stating that, you know, in this state, in this county, I, whomever the principal is, appoints whoever the agent is as of what date, and it's very specific to the loan in question, whatever the lender would be working with, the loan amount, all of that good stuff. And these do not get recorded. I know at the top you can kind of see where it says space above this line for recorder's use. They get filed with the county, but they don't make these a public record for the actual affidavits. The power of attorney itself will get recorded though. And these are just some of the doctor's checklist notes. And the reason why we have requirements on these now is because you'd be very surprised on some of the things we get back from a said doctor. So these are our requirements now. It must be written or typed on doctor's letterhead. It's very important. It must include the date it was prepared. It must include the doctor's signature. It should include verbiage that the borrower or the principal can no longer handle their financial affairs. And depending on the title or the lender requirement, the doctor letter may need to state the date that the borrower or the principal became incompetent. It's very important. We've had several situations where we have a power of attorney provided and it states that the borrower is incompetent as of this date. And then we go check the chain of title and we see that a deed was recorded in the same time frame that the borrower was deemed incompetent. So that's definitely not okay. We want to make sure that we always have everything dialed in, and we want to make sure that the dates match up. And we want to know that before we submit the file. So if ever you find out information and you're worried that it may have an issue, please just let us know, because we can let you know the best way to deal with it and move on and move forward and make sure that you submit a clean file with no issues. Apologize for that. It's my computer cord. All right, let me minimize this. Hope everybody's doing okay. I promise we're almost done. We will get through this, and we're almost through it. So just bear with me. About halfway, a little more than halfway through at this point. All right, so here's what a power of attorney can't do. It cannot be used for self-serving purposes, and that includes removing an incompetent borrower from vesting. It can't be used to sign on behalf of a trustee unless both the power of attorney document and the trust specifically allow for, and I mentioned that earlier. I won't get too deep into it. Like I said, each scenario is different. So if ever we run into that and we have an issue, your title or settlement team will always direct you on how we can move forward and move past it with the best scenario that's going to work for the borrower and the situation at hand. Here are some reasons for POA denial. If the POA has the lack of power to borrow or invalid signatures, that's going to be an issue for sure. If we've got an improper notary acknowledgement, that could be an issue, or even the lack of durability language. Some states require witnesses on power of attorney, so if there's an insufficient number of witnesses, that could pose an issue. A few more reasons would be there is a springing power of attorney provided for review, but the borrower is still competent, so that clearly won't work. As we explained earlier, springing only goes into effect when the borrower is incompetent. Maybe we have an insufficient doctor's letter, or maybe the original power of attorney is missing, and that is required for recording. Now, there are some states that do allow for a certified copy of the power of attorney to be recorded. It is a bit more of an involved process, and you do have to make sure that you have either an attorney or a notary that is willing to attest that they witnessed and saw or notarized at some point in time that original power of attorney. That's what they would have to do to obtain a certified copy. And again, that's state specific. I don't have a set list. I want to say California allows for that, but it is county specific. Although we know that these things are possible, every county interprets it different. So one county to the next may or not accept it, even though we know that this is possible. This is the workaround whenever a power of attorney is missing. Some counties we have had that will not record that document. So I'm just giving you guys the information. We don't make up the rules. We just try to give you guys the best information that we can, and I want to make sure I'm sharing that just in case anyone does run into that situation. You kind of know what you may or may not be able to do and how to move past it. Okay. Here is going to be a sample signature line when you're dealing with a power of attorney. And this is, again, kind of what I mentioned earlier about the trustee signature lines, where for us in title, it's second nature. We know how it should be, whether it's spelled out or not. But sometimes the borrowers, obviously, they don't know, and sometimes maybe the loan officer or the broker may not know either. So we want to make sure we're educating you guys, so that way maybe you're at a loan closing with a notary and you notice that they're not having them sign the proper way. You can absolutely step in and say, hey, no, it should be like this, and you give them that example. Or just give us a call if ever in doubt, and just let us know your question and we'll walk you through it. But if the borrower, Jill Smith, has a power of attorney who is Jack Smith, it should look something like this: Jill Smith by Jack Smith as attorney in fact. And the signature lines, in essence, would probably just say Jill Smith, but the power of attorney must sign Jill Smith by Jack Smith as attorney in fact. That is exactly how that signature line should read, whether or not that wording is there or not. That should be the standard. All right. So I told you guys we're almost done. So now we're just going to talk about quickly using a trust and a power of attorney in a single transaction and how that works. So when a trust and a power of attorney are combined in the same transaction, you have to follow the guidelines as previously discussed within the presentation. These entities are separate and they should be viewed as such. It's common to have a trust and a power of attorney used on the same transaction. However, there are going to be circumstances where a trust can be denied, yet the power of attorney is approved, or vice versa. And that's, again, going to be specific to each individual document and why that would happen. So when we're dealing with a competent borrower with both having a trust and a power of attorney, if the borrower is the trustee of the trust, the borrower should be the one signing all the documents as trustee unless there's a different trustee that's appointed. The borrower must sign the principal's affidavit, and then the power of attorney must sign the affidavit of attorney in fact, and then the original power of attorney would be required for recording, again, unless it's already of record. Now, if we have an incompetent borrower, we're going to require an affidavit of change of trustee, and that's going to be required if the borrower was the trustee. The successor trustee would be the one to sign all the documents as trustee versus the borrower. We would likely require a doctor's letter confirming the incompetency of the borrower, and then the attorney in fact would have to sign all of the documents for the borrower as individual. We would need the POA to sign the affidavit of attorney in fact, and then we would also need the original power of attorney to record. And just as a note, the attorney in fact is not always going to be the same person as the successor trustee, and that's perfectly fine. So for the vesting, the trustee should sign in the capacity of the trust, and the attorney in fact, or the principal, must sign in the capacity of the individual. So again, two separate entities, the trustee or successor trustee will sign on behalf of the trust, and then the POA will sign all documents for the borrower as individual. And then here's going to be an example of how the signature line should look, because at the top, you've got the person who is signing as individual. Our individual would be Jill Smith. Her POA is Jack Smith. So if she's competent, Jill Smith by Jack Smith as attorney in fact would be signing on behalf of her as an individual. But if she's competent, she would sign as trustee for herself as just on the trustee documents. So that's how it should look. Now, when she's incompetent, that's where things would change a bit. Jack Smith would already be signing for her as power of attorney on the top line, Jill Smith by Jack Smith as attorney in fact, but then on the bottom, he's now the successor trustee. So it would just say Jack Smith, trustee. And it doesn't necessarily have to say successor trustee. As long as it says trustee, that signature is representing the signature on behalf of the trust. So you might see it with successor trustee sometimes, and sometimes you might just see it as trustee, and that's totally fine. Either way works, as long as the word trustee or successor trustee is written after that trustee signature, it's a good signature. All right, now with regards to dispersing the file when we're dealing with a trust and a power of attorney, this is very important. We do our best to make sure at the onset when we get an open order that we see the vestings in a trust, or maybe the order got opened and maybe we're going to vest into the trust. At some point in time up front, we know that there's going to be a trust involved with disbursement. So these are some of the things that we added to this webinar just to make sure our brokers and loan officers were aware of what they should be, telling their borrower, asking these questions up front, because they should have a bank account in the name of the trust. If they're going to vest their property in a trust, they should have a bank account in the name of the trust. That's how it should be. Is that how it's going to be? 98% of the time, no. Many borrowers do not set up their estates this way, and that's okay, but we do need to make sure that we're letting you guys know. We will always ask for permission if we get to funding and the borrower does not have a bank account in the name of the trust. We will always ask the lender permission. Do you give us permission to wire to the borrower as individual if that was their request, and we wait for your approval to do so. Otherwise, we would issue a check in the name of the borrowers if that was their request to do so. So just please be mindful of that. I know it's not something that has always been that way, but just with a lot of the fraud that has been happening in our industry over the last couple of years, we've done our best to make sure we are protecting the borrowers the best way we can and their finances. And so this is just something we came up with that we feel is for their benefit. When dispersing a file in a trust, if the borrower requests a check for their proceeds, the check must be payable to the name of the trust. We will be unable to issue a check to an individual capacity if vested in a trust. And again, I just mentioned, we will always check with you first, but this is the standard. We have a set standard, and then we have to accommodate as necessary if the borrower does not have that. And it's going to be the same thing for a wire. If the borrower requests a wire transfer for their proceeds, a checking account in the name of the trust will be necessary, and if the account in the name of the trust is not available, we will be unable to send a wire. Again, we are always going to ask permission. We will not just simply not adhere to the borrower's request, but again, as a note, these are things that we are looking for whenever we see a property vested in the trust, and we will let you know up front when we get the order. We will let you know when the file is clear to close, when the final fees are sent over, and we will also let you know once the file goes to signing and remind that notary to obtain a voided check in the name of the trust. And most times that's likely when we find out. So we'll let you guys know when we're dealing with the funding conditions, and we'll hopefully get approval before that wire comes over to us, so we have it all dialed in. Now, when we're dispersing with a power of attorney, things can vary just a bit depending on whether the borrower is competent or not. So if the borrower's proceeds are going to be issued in the form of a check, they can only be made payable to the borrower. So even if the power of attorney signed everything, that's all great, but we have to make the check payable to the borrower, not the power of attorney. We do get requests asking us, oh, can you send the check in the name of the power of attorney? They handle my account. We cannot, unfortunately, with the power of attorney. Now with the wire proceeds or the instructions for the borrower's proceeds, they can't be accepted from the attorney in fact, meaning when the documents are being signed, we're only requiring the borrower to sign the principal's affidavit as individual. But if they want a wire, the borrower is the one who has to fill out the wire proceeds form. The borrower has to be notarized, and it has to be the borrower providing the notary with the voided check and all of that information. And then we can wire the funds to the borrower's account. So if the borrower is incompetent, the power of attorney cannot sign the wire proceeds instructions form on behalf of the borrower. So a wire to a borrower with a power of attorney, that only works when the borrower is competent. You just want to make sure that's very clear. So we can accept the wire instructions from the borrower to the borrower's account. The instructions cannot be completed by the power of attorney. They have to be completed by the borrower. And then in regards to wire fraud, this is also something new. I think we've been practicing this for about the last year or so. With regards to the closing, we can only accept wire instructions provided to our office by the notary at closing. After the closing, say for instance, there's some funding conditions or funding issues and the borrower, maybe they wanted a check at signing, but then they changed their mind and they wanted a wire instead. After the signing, we can't accept that. I would say the borrower, if they came into our office, which again, we're a nationwide company, we're not going to have borrowers coming in after the fact to give us, live checks and signing instructions right now. So we just try to make it very clear, if the borrower wants a wire, they need to have everything available at the signing, because after the signing, we can't alter what's been provided. It's, again, for the borrower safety. We don't want to accept anything via phone or via email from the borrower. We have had some special circumstances where maybe, we've had to verify bank accounts specifically on our end because maybe, the borrower maybe had a stroke or maybe something happened that became an emergency. We will work with the borrower to try to be as accommodating as we can, but our set standard is to not accept any wire instructions outside of closing. We want to make sure someone physically handed information to our company, which is on behalf of the notary, and that's how we set the file up for wire. So please let your borrowers know whenever they're going to closing. Make sure you're signing those wire instruction proceeds at the actual closing, because we don't make any changes after the fact. And again, it's for their protection and for their safety. And that is pretty much it. All of this information that we just went over is updated as of April 1st of this year. And information is going to vary by underwriter or by state. We ask that any questions that you have, please feel free to reach out to us or your settlement teams if you're already working with us directly, and we will always make sure we give you the best information on your files. And with that, I'm going to open up this questions box, and I'm so sorry because you guys have all been muted, but your questions, you are all more than welcome to email me directly. Again, I'm Angel Booth, and my email is abooth@prclosings, and that's plural with an S.com. Feel free to ask me any questions you'd like, or you can also email our client services box, and you can ask any questions you need there. The email to client services is listed there, and our phone number is listed there as well. Please take the time to go check out our website. We've got a YouTube page, and we have some other recordings on there as well, different things that we cover. So if you are interested in any of those, please feel free to check them out and ask as many questions as you like. I'll be happy to help in any way that I can. Again, Adrian, thank you so very much for allowing us to put this on for you guys. I'm so sorry again for the technical difficulties we had starting out. Yolanda, I'm not sure if you have anything that you want to add at all.
No, just thank you guys for your time. We value our partnership, and we hope that you guys found this really informative. I know that there was a lot of information. And again, like Angel mentioned, we will have this recording available on our YouTube channel, hopefully by the end of the day. If not, it'll definitely be there for you to look at later, or, again, if not by the end of the day, tomorrow and further. So thank you guys very much. We really appreciate your partnership and your business, and we look forward to working with you.
Yes, thank you so much, Yolanda. And I just got a text from Adrian, and I will, yes, Adrian, I'm going to, we have the registered attendees, and we will absolutely email it out to you guys as well. So I think that's it. I think I stopped talking your guys' ears off, so you are welcome to go enjoy the rest of your day. Thank you again. I guess we hope you guys have a wonderful rest of the day.
Thanks, Angel. Thanks, everyone.
Okay, bye, guys.